Okay, it's 11:03, so why don't we get started? Folks can still trickle in as they'd like to. Just to introduce myself, my name is Jessica Keegan. I use she, her pronouns, and I'm coming from the Office of Economic Empowerment, which is an office of the Treasurer and Receiver General of Massachusetts. And we're very, very happy to partner with Brendan Malloy of Insight Financial Horizons. And of course, the Topsfield Library to bring you this estate planning workshop. So first, I'll just welcome you with some remarks, then we'll go into some disclosures, and then dive right into the action for the estate planning workshop, and we'll have time for some Q&A. But let me just say that if you have any questions, I'm speaking to both our virtual crowd and our in-person crowd, definitely let us know. You can put those questions in the chat. We'll make sure to get those to Brendan, or you can mention them to Rebecca if you're in person, and we'll make sure to also make sure those arise, as I know this can be a complicated subject. So the Office of Economic Empowerment, if you haven't heard of us before, we are, as I mentioned, a department with the Office of the Treasurer. We try to offer free and accessible financial education. We try to promote wage equality and equity, and we also try to make sure that we have equal opportunities for children across the state. So keep an eye out if you are somebody who likes the older adults programming. We're happy to come and give you some more topics. We also have great resources online. If you're not sure about financial decisions or next steps, you can visit myfinanciallifema.org, which gives you some great instructions modules, and I'll put that in the chat as well. So for those of you who are virtual, you may have noticed that this is a Zoom webinar. Zoom webinars are a little bit different than Zoom meetings, which means you can't come on camera, you can't speak, but that's okay because you can still ask questions in the chat. And like I said, we'll monitor those. There is also a Q&A. So this will be recorded and then put on our public YouTube channel. We'll make sure Rebecca gets the link for all of you who are interested in that, as well as for the folks who signed up to be virtual with us. That'll come to you in a follow-up email, so you can refer to any part of this conversation, this workshop, again, when you need to. And of course, any information shared through the question function will be anonymous, but this is a state organization presenting, so we are subject to public record laws if those arise. So let's turn it over to Brendan. Very exciting here. And like I said, let us know if you need anything. Go ahead, Brendan.
Okay. Well, thank you, Jessica, and thank you, Rebecca. I'm very happy to be here. And my name is Brendan Malloy. I'm a financial advisor in Danvers with Insight Financial. And I love the town of Topsfield. My parents and sister live there, so I'm very happy to present this. I hope that the takeaway is that you, if you had questions, and hope that you can take some value out of this. Estate planning can be complicated, and everybody really wants to do it the right way. So, it's my goal that this information can help you in some way. So, estate planning, it's really the process of creating a master plan for managing your wealth during disability or after death. And it's an opportunity for choosing to whom and how and when your assets will be distributed, ideally at the lowest possible cost because of estate taxes. And common issues addressed during this process include many, but navigating estate taxes, protecting your family's assets, funding charitable causes, providing financial security for your loved ones, planning for children of a previous marriage, retiring from a family business. So it's pretty complicated. Going through the estate planning process, it might be a little different than what you would expect. The term estate planning, it often conjures up thoughts of transferring wealth to your loved ones. But your family's goals and values are much more nuanced. So taking that into account is important. And a successful estate plan should always consider those values, even if they result in a less tax efficient planning. So it's up to people who can help you with your estate plan to really identify the gaps or the inconsistencies in your existing plan so that you can really have the most efficient asset protection strategies in place. You know, we hear often about the celebrities and their issues with estate planning. They're in the press and in the news, and you know, they're the family members, the courtroom battles they play out in the public eye. So one example, Michael Jackson, his family was involved in a legal battle over his will and the division of his estate and all the payments of his debts. And one issue that came up was who's going to be the guardian of his children. Farrah Fawcett, she died, leaving a son who was in jail and who also suffered from addiction problems. And as her only child, Redmond, should he inherit all of her wealth? You know, did her will specify that he was to receive all the inheritance? You know, she also had a bitter divorce with her husband. So, you know, how did all that play out? And did she set things up in the right way to provide for her family? Dennis Hopper, another existing interesting example. When he died, he was engaged in a bitter divorce battle with his fifth wife, and the fight moved from divorce court to probate court, where, you know, her benefit from his estate might differ from what the divorce settlement said. There's Gary Coleman. When he died, there was a variety of documents that surfaced reporting to be his will, including a handwritten will presented by his ex-wife. You know, she claimed that she was entitled to inherit all of his assets. And most recently in the news, Prince, the singer, his estate was just settled after a 6-year court battle. When he died, he did not leave a will. He didn't have a will, and he had a $156 million estate. So his 6 half siblings were named his legal heirs. So could that happen to you? The legal troubles that all these celebrities have faced, it should remind us that it's important to really get your own affairs in order. And without planning properly, you know, your families could find yourself in the same kind of courtroom dramas that you hear about in the press. You know, most people are surprised to learn that there's simple things that you can do, or simple factors that can cause your estate plan to fail, or your family members to end up in a courtroom battle. So we'll go through all of that just to identify those things that are crucial. And so now I'll go into the top 10 most common estate planning mistakes and how you can avoid them. Number 1 is failure to plan. So too many people fall victim to this first mistake. You know, we all need some level of estate planning, regardless of our net worth. And did you know, you might not know this, but everyone in this room already has an estate plan. And that's right. If you have not created one for yourself, the state has done it for you. Every state has an intestacy statute that governs how your assets will pass. And the laws they vary from state to state, but your surviving spouse most likely won't inherit the entire estate. In most states, the estate's divided between the decedent's spouse, children, sometimes even the decedent's parents. And if there's no surviving spouse, children, or parents, the assets continue down a linear line to other heirs. So, you know, would your spouse be surprised to find out that they were disinherited and that a portion of your assets now went to your son or daughter? That's why it's important to have estate documents in place. If you do pass away without an estate plan in place, there's other issues that'll come into play. Number 1, who will be the guardian of your children? Your estate documents, they allow you to designate individuals to look after your children and to specify individuals you'd prefer not to take on that role. So, you know, appointing guardians is very important. And if you die without a will, the probate court, they will appoint someone to manage your personal and financial affairs under court supervision. So no will, the court will decide. Depending on your assets, your outstanding debts, and any ongoing obligations, such as like a business interest, the probate process may require additional time and expense too. So it can get very costly if you have to have your assets go through probate court. So, minimizing that and ensuring that your assets and don't have to go through probate is an important part of the process. An estate plan, it can also help you structure your assets to minimize federal and state taxes. Lastly, keep in mind that if a living beneficiary is not identifiable, the state may become your beneficiary. So many people if you don't have a family, you'd probably prefer your assets to go to a charity or other individuals rather than the state. Even though you might love your state, you should sure you would want your assets to go somewhere else. Number two of the most common mistakes would be a failure to implement. All too often, people, they have an estate plan drafted, but they fail to implement it. Some are under the impression that signing the documents is all that's required. And in fact, a number of action items usually need to be completed, such as retitling assets, changing beneficiary designations, and balancing the estate property. Most attorneys, they provide their clients with instructions for retitling the accounts and changing beneficiary designations. But these important tasks are often overlooked. So, they give you instructions on what to do, but sometimes actually taking it to the next step and getting those changes implemented doesn't actually happen. So failing to implement an estate plan, it really can have the same undesirable results as failing to plan altogether. And once the initial process is done, it's important to follow up on any action items and work closely with your attorney to actually get these action items done. And if you don't do it, failing to do so may cause an otherwise good estate plan to really become ineffective.
Brendan, may I interrupt with a question from our audience?
Oh, yes, of course.
Okay, we have a question. How does a trust interact with a will?
Well, a trust interacts with a will, in the sense that a trust would avoid probate court. So if you do have a trust in place, so a will, that does not avoid probate court. So if you have a will, that the will would be the document in probate court that outlines and allows so that the state doesn't determine how to distribute your assets. The will would. A trust would avoid probate and identify how to, but the important thing about that trust is it needs to be funded. Just having a trust or having, if you have assets and they're not in the name of the trust, if they haven't been titled correctly so that they're actually in the name of the trust, then that doesn't actually, help. So yeah, a trust avoids probate, but you got to make sure that the assets, if it's a house or if it's in a brokerage account or a bank account or you got to have it titled so that it's in the name of the trust so that those assets can be distributed how they want, which would avoid probate. So, a will can, identify a trust and specify that to put assets into trust after you pass, but, having a trust, and a will at the same time, you just want to make sure that you actually put those assets in the name of the trust. Because if you don't do that, if you don't fund the trust, then it sort of, doesn't really help there. You got to make sure that you change the name of those assets into the name of the trust, and then you'll have a really smooth process for distributing those assets.
Great.
All right.
Thank you
next,
so much.
does that, okay, hopefully that helps. The next common mistake would just be failure to update. And, you can imagine things happen in life. There's all sorts of different events that happen that, at a minimum, you really should update your plan whenever these things happen: marriage, divorce, birth, or death of any loved ones that are in your family. And if you don't, you may unintentionally include or exclude beneficiaries. So keeping that in mind, that if things happen, that you most likely would also need to update your estate documents. You might also need to update your plan based on changes in law, or if you have significant increases or decrease in the value of your estate, because there's tax consequences based on the value of your estate, or changes in your planning needs and goals. So legislation governing federal estate and gift taxes, that continues to shift, especially in our state. There's discussions underway right now to increase the Massachusetts estate tax threshold from 1 million to 2 million, which would be a very big change for people and would help people out in this state. So naturally, estate docs should be updated to reflect these changes if they do actually get voted into place. Right now, the Massachusetts estate tax threshold is $1 million. So if you have an estate that's over $1 million, then you're required to pay a mass estate tax. If it's $999,999, you don't. Overall estate value, that often does drive how an estate plan is constructed. So if your values of your estate increase or decrease significantly, then plans may need to be amended or accommodated for these changes. And your estate plan should also be updated if your goals change. For example, a trust, if you created a trust that was designed to manage funds in the event that your children are minors when you pass away, and when you pass away, that as they get older, you might you don't really need to have them have it be structured that way. So you'd probably want to update that trust as they grow older to distribute those funds in a different manner. So it's just as situations change, as goals change, as your family changes, so should your estate plan.
Great, Brenda, we have another question.
Sure.
So for new assets purchased after a trust is done, do you put them in the trust's name?
Yeah, so assets that are purchased after the trust is done, so you already have the trust in place and you have a new asset that you've come into. So if that asset should be, if you want it to follow the same distribution, the same plan that the trust outlines, then yes, put it in the name of the trust. If that asset, if you have a different idea, because if you just name beneficiaries of an asset, then that supersedes a trust or a will. It goes before it. So, for example, if you just purchase an asset and you have a specific wish that you want your nephew to be the one that inherits this one specific asset, then you can just name one beneficiary to that. It doesn't have to necessarily be the trust. If you want to have consistency across your assets, then putting that new asset into the name of the trust would just make sense, naming beneficiaries is one of the biggest keys. If you have the opportunity to name a beneficiary on any asset, you should, and you should have it be consistent. Some even name the trust as a beneficiary just to keep things very efficient and consistent. So yeah, I would say that if a trust is already created and then you purchase a new asset and you want to keep things consistent with your estate plan, then have that new asset be put into the name of the trust. So next, which goes well with what we were just talking about, is failure to review your beneficiaries. Improper, unintentional beneficiary designations, those can really hamper an estate plan's effectiveness. So all too often people ignore them, and these are beneficiary designations on 401ks, 403bs, IRAs, annuities, life insurance policies, transfer on death accounts, and so on. So if you neglect these designations, you may unnecessarily subject your assets to probate. If you don't put beneficiaries on, then it's a probate asset. Or unintentionally include or exclude a beneficiary, such as an ex-spouse. So it's important to remember that beneficiary designations are contractual agreements that supersede the provisions of a will or a trust. So they go ahead of it. Your trust or your will can say one thing. It could say that you want your assets to be distributed this way. But if the named beneficiary on an account is named, then that beneficiary gets that account regardless of what the will or the trust says. So always look, you might have a lot of different accounts out there, and just making sure that you know who the beneficiaries of those accounts are is really important, because sometimes you might forget that you have, sometimes it's people have their spouse that passed away, and they have never updated it. And if that's the case, then that's a probate asset, because that person if there wasn't a contingent beneficiary on there, then you have a beneficiary that's no longer with us. That's a probate asset, and that could go to probate court, be held up, and could cause unnecessary drama. Next is just the failure to understand your plan. These plans can be complicated, and it's just important to try to understand how your plan works. And for many people, the tax planning part of it is probably the most confusing. Up until recently, there was a technique that a lot of people used if they had significant assets. It was called an AB trust, where it involved the use of a marital and a bypass trust. And but now there's an act that was enacted in 2010 that was the portability provision of the Tax Relief Act, that spouses, they can take advantage of their deceased spouse's unused estate tax exclusion amount without creating a bypass trust. So it's just important to know that one detail, that it's not as necessary now to have these trusts created to have your assets not be part of your estate, to be held out of your estate. Now you have a much higher federal tax exclusion now, and there's the portability provision between spouses. This one, number 6, is the failure to make lifetime gifts. So if you do have an estate that's near that $1 million mark right now, obviously that'll change if it gets increased to 2 million in Massachusetts. But right now, the IRS, they allow taxpayers to give away a certain amount of cash or assets each year to as many individuals as they like without incurring the gift tax, which really means without filing a form that said you made a gift over that amount. So if you make right now, in 2022, the annual gift tax exclusion amount is $16,000. So if you make a $20,000 gift to some individual, you're required to report that on your taxes, that you made a $4,000 gift over the exclusion amount. And that would just reduce your lifetime exclusion amount. It's not like you actually have to pay taxes on that gift. It just reduces your lifetime exclusion amount when you pass. So people with taxable estates or estates that are near that $1 million mark, you really should consider a gifting program. And the idea is just to take advantage of the gift tax exclusion to reduce the size of your estate, and therefore the potential tax on the estate. And that's a unique opportunity to transfer significant assets to your loved ones. And you can really enhance it too through the use of estate planning vehicles like an irrevocable life insurance trust or 529 college savings plan. So you can make gifts to your grandkids' college funds or your kids' college funds up to that limit. Don't have to fill out a tax form. It does not reduce your lifetime exclusion amount, and you're helping them with their college funding. So number 7 would be choosing the wrong fiduciary. When asked to name a fiduciary, such as a guardian, a trustee, executor of your estate, most people, they name their closest relative. And this may be appropriate in some cases, but often it's a mistake. A parent, a sibling, close friend, who doesn't understand the duties associated with acting as a fiduciary, they may be overwhelmed when faced with interpreting the document provisions or determining what's best for the beneficiaries could cause conflict. And so the appointed fiduciary, they may be viewed as the bad guy, the one controlling the assets, which puts them in a difficult position, even if they're acting fairly. And so a poor choice can really lead to family conflict. And for this reason, it's important to consider who will act as the fiduciary of your estate. And you may be better served by naming an unbiased third party. You could name a corporate trustee, and through, an example, our broker dealer, we have access to corporate trustees that can perform this role. So if you don't want to put family members into a position of potentially being made out to be the bad guy, you can obviously have a third party be designated as the fiduciary or executor of your estate. Another common mistake is just a plan that's way too simple. Some estate plans, they might be too simple to transfer the wealth and minimize taxes. An example would be just the all to spouse arrangement, where you have just a really, really simple will that just says give everything to my spouse. Or those people who just they take the I'll be dead anyway position, which may cause their assets to pass to unintended beneficiaries, or it could subject their estates to greater administrative fees. People facing an estate tax, if you have an estate that's over $1 million in Massachusetts, you should consider that the federal and state government will become your beneficiary if you refuse to properly plan. If you just don't, take that I'll be dead approach, the state will really become your beneficiary. And if you don't feel that your heirs have enough, you can always explore charitable planning as an option. So if you think, your heirs are doing just fine, rather than having your money go to the state, you can have it go to charity. So on the other end of the spectrum would be a plan that's too complex. And that would be, a plan that you don't even understand how it works or why you implemented it in the first place. That is a common mistake. And it's really important just to focus on what are your goals that you want to achieve and what's the most efficient manner of achieving them. Is it asset protection? Is it having liquidity so that after you pass, your heirs can get at your funds and take care of estate taxes and have solid liquidity? You should really feel comfortable maintaining that your estate plan and keeping up on those tasks. And if you're not administratively inclined, then are you willing to pay someone to help you out? Complex estate planning does have its place, but with it comes additional duties in the form of annual state, federal tax filings, beneficiary notices, and keeping up with all the rules that the IRS puts out there. So the worst plan is really one that's failed from a lack of attention. So trying to find the happy medium between a plan that's too simple and too complex, it's really just a plan that meets your needs and the values of your family is most important. Lastly, one of the most common mistakes would be just a plan with no flexibility. So most estate plans, they really need some level of built-in flexibility just to meet your needs and the needs of your beneficiaries as things change. You can ask yourself, does the documents that you have in place and the overall estate plan, does it allow you to make decisions in light of your current goals? Does a trustee have the appropriate amount of discretion to make necessary distributions? Can they actually, make changes if they need to? That irrevocable means you can't make any changes. So if you have an irrevocable trust, yes, it's out of your estate, but you truly cannot make any changes to that. And if minimizing taxes is a goal, do your documents contain flexibility to accommodate changes in the law? Because we know tax changes occur quite frequently. And so the answers to these and other questions, they can really help determine if your plan is flexible enough to meet your changing goals and needs. And lastly, just talking about the issues, it's steering clear of these pitfalls to really avoid them, and keep your heirs out of court. It's important just to discuss these wishes with your family and other individuals that you trust who may be involved in carrying them out, such as your estate planning attorney, advisor, trusted contacts in your family. So having, these conversations and talking about them is important.
Let's talk about a question in the chat, if you don't mind, Brendan.
Sure. All right.
We have a question that says, are there tax benefits between revocable or irrevocable trusts? Excuse me.
Yeah. So if you put assets into an irrevocable trust, then that's out of your estate. And so when you pass, then those that you've basically gifted those assets away. You've relinquished ownership of those assets, and so you wouldn't be on the hook. Your estate would not be on the hook for the estate taxes if you do put assets into an irrevocable trust. If your assets are in a revocable trust, then those would be included in your estate. You can make changes. They're very flexible, and they can adjust when your situation changes. But that is included in your estate. So if you wanted to avoid or minimize estate taxes, if that's one of the main goals, yes, you can put assets into an irrevocable trust. You could still have that irrevocable trust pay income to specific people, even the grantor, the one who's putting the assets in for their life. So it's not like you give the funds away and you can't really they still can't work for you. Yes, they can provide you with all the necessary income that you need. It's just it would be out of your estate. So there's clear tax benefits to putting assets into an irrevocable trust. The only tough thing is, once you put them there, then you lose flexibility because you've given those assets away to that trust, and you really can't make further changes once you do that. So that would be the differences in tax benefits between revocable and irrevocable.
Thank you.
Welcome. So identifying the common pitfalls and some mistakes is important, just to kind of get you thinking of how it works with your situation. But I thought it would be helpful just to also follow up with just a 4-step guide, really, to if you don't have an estate plan, or if you do have one and you want to revisit it, or just see if it's, this would be, the 4 steps to take to create one or update your existing plan. So number 1 would just be organizing your current plan. And, it's taking the time to gather all your current estate documents. That would be account statements, beneficiary designations, tax returns, any financial plans that were previously drawn with your advisor. And then draft a summary of these documents that you have and really outline how they protect your estate goals. So it's just identify the documents you have and try to outline how they help protect you. And this will just help with, you and any advisors that you have working with you, just to figure out if anything's lacking, like those gaps and inconsistencies. Once you kind of identify the current docs, then you'll be able to determine if there's any gaps. And the most common documents are the will. So number 1, the will's the most common, probably most important. It allows you to choose whom and how you'll give your property to your beneficiaries, and to set up trusts to protect them in the event of your death. You can also name someone to handle your affairs in your will. This would be the executor. They don't avoid probate. So that's important to know, but they do assure that your wishes will be executed. So during the probate process, without a will, your property is distributed to heirs according to state law. We talked about that before. The second most common and most important document is the power of attorney document. And this allows somebody else, while you're alive, an attorney in fact, to handle your financial affairs or to make healthcare decisions on your behalf if you're unable to do so. The important powers, those typically include the ability to make a revocable trust irrevocable. They can apply for government benefits on your behalf, change beneficiaries of insurance policies or retirement plans. They can facilitate long-term care planning, even exercise stock options for you. So it's very important to actually add power of attorney documents to your accounts, and to remember that the power of attorney is no longer valid after someone dies. It's that document ceases when someone passes away. But if you have an account and you want to make sure that if anything happens to you, if you become incapacitated and you still want to have your power of attorney be able to assist you with that, you have to make sure that that power of attorney document is actually added to the account. That's an important thing. You might have the document, you got it done, it's a legal binding document, but if you don't actually add that document onto your brokerage account, your IRA, then that person can't actually help, because it needs to be added to the account in order for that actually to be valid on that specific account. Healthcare proxy, another important one, that designates who can act as a patient advocate and who can make medical decisions on your behalf. And it's not to be confused with the living will, which deals with issues of artificial life support. Your primary doctor should have a copy of your healthcare proxy on file. Another common estate doc is the Revocable Living Trust, and that's a legal entity that can help avoid probate in the event of your death. The assets, they're given to the trust by a grantor or settler. That's the person who actually funds it, who has the funds. And they may be, the motivation behind creating one might be achieving a smoother transfer of your assets in the event of your death, among many, that's really the most important one, of just a smooth transfer, so that it avoids probate, assets get distributed to the people you want. And if it's revocable, then the grantor, the person who funded the trust, has all the rights to the trust and its assets. They can make changes, but a successor trustee can step up without any disruption on that. And lastly, the beneficiary designations. These are non-probate assets. So an account with a named beneficiary, non-probate. This is like jointly owned property, life insurance that has a beneficiary on it, annuities, retirement plans that have beneficiaries. They're not governed by the terms of the will or the trust. It's just important to coordinate these, make sure that they're correct, so that your estate plan does not go awry. As we talked about before, having someone that you don't intend as an old beneficiary that you didn't update really can have a negative effect on the overall plan. So the second step of just this 4-step guide would be assessing your needs. So you've gathered your documents first, you've got that outline of documents. Next is meeting with someone that you trust, an advisor, trusted family member, just to evaluate whether your current plan, you can do it yourself too, if you just kind of spend the time, but it's helpful to have other people to kind of bounce these things off of. And just to evaluate whether your current plan's in line with your wishes. This meeting really can be most effective if you come with a list of questions that you have about your plan, and these questions can go way beyond what's covered in those written documents. When you do meet, with your trusted person or an advisor, they will likely have many questions of their own too, to help prepare for when, the next step would be to meet with an estate planning attorney or an accountant. And, there's lots of different, this is where everyone's unique situation comes into place. Everyone, there's so many different aspects of everyone's lives and how to address each unique family situation. So, some questions to think about would just be general, just how do you want your wealth to benefit your children, grandchildren, your community? What do you want trust to do for you and your family? Would your spouse need income from the trust after you pass? Do you have a special asset? Do you have a business? Do you have a vacation home that should, retain or stay in your family? Explain your choice of your trustee executor. Do you feel comfortable with that person? Are you currently helping family members meet their goals? Because if so, then in the plan should accommodate for that so that can continue. Has your health changed since you last reviewed your estate plan? Special family needs. This is a big one. Who's dependent upon you and your income and the support you give? Have you named guardians for your children? And do you have children from a previous marriage? What do you want for your spouse after you pass? And do you have a family member that has special needs? Because that can really lead to some specific things with certain types of trusts and how they're written so that person with special needs can get taken care of. Do you have someone who's inexperienced with money in your family that you don't feel comfortable that they would, have the ability to handle the funds that come their way in a responsible manner? Business needs. If you do have a family business, when would you step down? Do you have a target retirement date? Do you have a buy-sell agreement? There's lots of nuances that go into it if you do have a business. And what assets, would the estate need to liquidate in order to pay estate taxes if you do have a business that's sizable? There's plenty of tax needs and questions that would come up from a tax perspective, like how will the estate taxes be paid? Where would those funds come from? And does your family understand how IRAs are taxed when you inherit them? So there's all sorts of new rules now based on fairly recent legislation changes where if you're a non-spouse and you inherit an IRA from somebody, you have to withdraw those funds over 10 years. You used to be able to stretch them out over your lifetime, which would really help people. But now the government has kind of changed their stance on that they want to get their taxes. Any funds coming out of an IRA are taxable. So they want their tax money a lot sooner. So they've now sped that up. You have 10 years to take it out. You can take it out slowly just so it doesn't have one big tax hit, or you can wait, take it out in year 10. But you have to fully withdraw that IRA that you inherited from somebody over 10 years. Last would be just telling your family about your estate. How prepared is your family to receive your wealth after you die? And have you explained your estate planning to your family? Do they understand it? And have you given trustees and executors instructions on how to and any guidance, just so that they don't get caught off guard and have all these responsibilities that come their way without kind of getting a heads up on them?
Great. Can I interrupt you with another question?
Of course.
This one is about online estate planning. So they ask, are the online estate planning tools and programs available satisfactory to get what you've discussed done?
Yeah, they are if your situation is fairly simple. If it doesn't really involve like the special needs of the family with certain individuals that you need to really look out for in a different way and put some additional thought and have the wording of those documents reflect that. If you're situation is fairly simple in nature, then yeah, trustandwill.com is a great website that can, I believe LegalZoom also, they've been in business for a long time. They will, you can get your will, your power of attorney, your healthcare proxy documents created efficiently, inexpensively, and they are legally binding and they will do the trick. But if you do have a sizable estate or issues that require, further discussion and nuances within, then definitely going with an attorney and being able to sit down and explain that would be the way to go, because those documents from those online estate planning sites just wouldn't accomplish things in the way that you would need them to, most likely, because they're more intended for just getting the documents done in a simple, efficient, quick manner and having them be pretty straightforward. But when you have the time to be able to go and meet with a estate planning attorney and discuss all the different nuances, then they would be able to provide more robust and appropriate guidance than those sites would.
Thank you.
You're welcome. So the number 3 would just be implementing your plan. So no, you've gathered the docs, you've met, you've talked about all the different nuances and issues with your specific family. Now you kind of have an idea of what you need, and it's really time to take action. So these are the steps that you can take before you meet with your attorney or go on to these online estate planning sites and take action on them. These are the steps to take before doing so. So one would just be creating a family tree. And this would, having one document that just lists all of the relevant family members and their financial situations. It really can be useful just in having these discussions with your attorney. Next would be stating your net worth. So this is like a net worth statement. It would break down the value of all of your assets and how they're owned, whether they're owned individually or owned jointly or owned by a trust. And they'll reveal the beneficiaries for those non-probate assets like your IRAs, 401ks, and that would help estimate the estate taxes for your estate. And that's what any estate planning attorney would want to see when you meet with them is your net worth statement. Titling of your assets properly, titling of your assets to reflect your plan. It's really key to protecting the estate. So if titled improperly, other aspects of your estate plan really can go sideways. And then, although a trust is really a powerful estate planning tool, it's ineffective if the draft doesn't actually own the assets. So you can have a trust written, but if you don't actually put the house or certain accounts in the name of the trust, it's ineffective. It actually doesn't really do much. So, taking that next step to title the assets into the name of the trust is important. And again, it's kind of like beating a dead horse at this point, but naming beneficiaries. There's several situations in which you're responsible for naming your beneficiaries to a retirement account, transfer on death account, which can be at banks. Banks have, checking and savings accounts at banks. You can have beneficiaries on them. They normally call them payable on death accounts at banks, but if you also wanted to have those accounts not be probate assets, you can just have the bank change it, add a beneficiary to that account. And it's crucial that these are aligned with the intentions of your plan, because they're, again, contractual beneficiary designations, which would supersede or come before any intention of a will or a trust. You can consider purchasing life insurance potentially to help cover estate taxes, and gifting assets that would reduce the size of your taxable estate, especially if it's close to the $1 million threshold. And advisors and they could help identify which would be the most appropriate or best for gifting. And if you do own a business, you could just review that succession plan, review a buy-sell agreement, and that provides, a jumping off point for both estate and retirement planning. And lastly, just to review the plan, it's a dynamic thing that changes constantly and requires continuous review and updates. So, so that we've talked about this before, but if you experience a life event, marriage, remarriage, birth of a child, divorce, disability, if you move to a different state, you got to consider the impacts on the family legacy, or and have these changes kind of update and reflect your plan. So even one little small oversight could diminish the effectiveness of the plan if you missed it. And a helpful way to stay on top of these changes is by scheduling regular family meetings. So it's just an opportunity for family members to talk about any changes or concerns in their lives, and that may impact the current estate plan. And if you don't talk about it, then that's probably the greatest barrier to estate planning. So carving out time in everyone's busy schedules, it's just an effective way just to align the goals of the estate plan to the values of the family. And it has a lot of moving parts, estate planning. The process is really smoothest when the family members and the people that they trust, such as advisors and accountants and estate planning, attorneys, everyone stays organized and communications optimized. So, this guide hopefully can help people stay on track to reaching their goals. And any further questions?
Thank you so much for that presentation, Brendan. There's so much useful information here, and we definitely have questions for you. Folks, virtually and in person, feel free to type your questions in the Q&A if you're virtual, or bring them up to Rebecca if you're in person. We have a few more minutes, so there is a good enough time for questions. We do have a question. It says, does an estate have an EIN that is separate through the government, not a social security number?
It does. Very good question. Yes. So when someone passes and it's not, then an EIN for the estate needs to be created. Yes, it's not that person's social security number. So, if you have assets that go into the sort of estate account, that you would need a separate EIN number for that estate. And that's something that you can actually get on your own. You can go and get that created, but if you work with someone at a financial institution, they can also help get that set up. And when a revocable trust, similar, when someone passes away, that trust automatically becomes irrevocable. If it's a revocable trust in someone's name, so when the grantor passes away, then it becomes irrevocable when they die. And that a separate EIN for the irrevocable trust, if you need to change that, you might need to get a separate EIN for an irrevocable trust after someone passes as well.
Great, thank you. We have another question that says, is there a free net worth template available somewhere?
Yeah, a free net worth template. Well, I'm sure that there's those financial planning sites out there. We use eMoney, which is that's what we provide to our clients, and that's how we provide net worth statements to everybody. Off the top of my head, I've seen some commercials. I forget the name of them, but I know that there's some free sites that would do that for you. I don't have the name off the top of my head, but I can provide Jessica, or we could send a follow-up to the attendees with that. There are some out there that are, I think Mint. There's a couple sites out there where you can kind of build your own little financial snapshot, personal financial snapshot, where you can actually sync up your accounts too. So you use these online tools where you connect just by going, you can connect that financial institution and put the username and password. And if you connect all the accounts that you have within this online software, your net worth is something that will update daily for you. That's what we use through eMoney. But there's free tools out there. Like I know Mint's one of them, and I can't think of some of the other ones. But yeah, if you do sync up those accounts, they're not transactional. So it's not, for privacy and security concerns, you don't have to worry about, it's really just informational. So you have these accounts, all your accounts in one place, and the account values will update daily. And so that's how you can kind of get an updated snapshot of your net worth if you do sync up those accounts in those software tools.
Great, thank you. I'm not seeing any other questions at the moment. I know it is almost 12, so if there are any last minute questions, definitely feel free to let us know. I'll just say again, thank you, Brendan. You are such a wealth of information, pun intended on the use of wealth. And if you feel like this was a great topic, this was something that you feel like other people would benefit from knowing, we'll have that recording up on our YouTube channel soon. And make sure that, we'll make sure that you're able to view this later. And if you are virtual right now, we'll send that follow-up link to you as well. Rebecca,
Hey.
did I hear some noise coming through on your end?
Yes, I backed up. Nope, still echoing. But I have another question, but it's a little bit of a complicated one. So I'm going to have our participant ask here. Go ahead.
Okay, quick definition of trustee, executor, and fiduciary and power of attorney. Can they all be the same person?
Yeah, they could all be the same person. They could all be the same person. A trustee is the person that is named in a trust document that would handle the affairs of that trust and is the one with the ability to make changes and handle the administrative tasks of that trust. And an executor is the person who handles the responsibilities of the estate. So different than a trustee, in that the trustee is the person who handles the affairs of that trust document, that legal entity that's the trust, and the executor handles the affairs of the estate. The power of attorney is someone who is responsible, who can be responsible while someone is alive. That power of attorney gives you the ability to handle affairs for someone while they're alive in the event that they need assistance, incapacitated or diminished capacity. And it's important that the power of attorney document, if you want them to be able to help with specific accounts, that they need to be added to that account. Not just having the document itself doesn't accomplish that. So that would be trustee, executor, power of attorney, and yeah, they could all be the same person. They don't have to be different. That would be if it's someone that you completely trust, then.
She also
It can
wanted
be
to
the
know
same.
what a fiduciary was.
Oh, so a fiduciary is just someone who is legally responsible to work in your best interest. So people with certain designations, like for example, the one that we have we're certified financial planners. So if you're a CFP, you are a fiduciary that legally has to act in the best interest of their client. So same with the power of attorney, you legally have to act in the best interest of the person that you have that privilege to be the power of attorney of. And so as a fiduciary, you have to act in the best interest of that specific person. And that's our legal obligation. If we're acting in the interest of ourselves, then we're not actually being the handling the responsibilities of being a fiduciary. So in order to gain the designation of, a CFP or other ones that are fiduciary designations, you have to go through kind of rigorous courses and exams and prove that you are able to handle those responsibilities.
Okay, I think that answers the question. I don't know why I'm still echoing. Our speaker died, but it still wants to echo. I just want to say thank you so much to Brendan, Jessica, and Jack for this amazing presentation. It was so helpful, so insightful. I personally don't have a will yet, and I have benefited greatly from this presentation. So I just want to thank you guys so much again for this. We're excited to have the recording for later. I know a lot of people are going to be interested in revisiting this information or passing this information along to a loved one. So thank you again so much for coming and presenting for us today. And we hope to have you back on some other subjects.
Sounds great. Thank you. I appreciate it. Thanks again for the time. And I hope that everyone took some value out of this. And if you do have any further questions, feel free to reach out to me. In Danvers, our website is wealth-insight.com, and I've got some good estate planning attorneys, especially in Topsfield, that I can recommend if anybody would like one, like a referral.
Fantastic. I'll make sure to pass that information along as well.
Great.
All right. And thank you everyone for joining us today. I think we'll probably end the webinar here unless Jessica has anything else she'd like to share.
Just thank you both so much. Thank you everybody for coming. If you have questions, definitely let us know. I will try to get this all out to you in a follow-up email, especially with that link to review what went on here. So thank you both again so much for your time. And that was a fantastic presentation.
100% agree. Thank you so much. We'll hope you have a great day.
You too.
Thank you all.